Thank you very much, Chairperson, and Dr. Mahana Mehewa, the Dean of the Faculty, and distinguished gathering. That my topic today is the interplay of Roman Dutch law and English law in the paradigm of contract law. This is basically a study of legal system of Sri Lanka, which relating to this contract law sphere. Actually, the contract law sphere of Sri Lanka and the legal system of Sri Lanka having many aspects. As Sir Richard Otterly in 1830 correctly pointed out, the laws and Ceylon are very multifarious. Therefore, that for this thing, there are two reasons. One is multiculturalism. As a result, we have got three special laws, namely Tesavalame, Kandyan law, and Muslim law. On the other hand, we were under rule of three European powers for 3 centuries. Therefore, we have got Roman Dutch law and English law in our legal system. Consequently, Sri Lanka blessed with two major will be governed by Roman Dutch law, which part will be governed by English law. That's a main problem. That we have got a scholarly writing from Professor Veeramantri in his work in 1967, Law of Contract. He mentioned two systems so rich and varied must, by coexistence in one jurisdiction, necessarily cross-fertilize each other for collective wisdom and experience enshrined in the one or two pressures for the other one to ignore. When there's this kind of application in legal system, there can be two conclusions. One is it may create complexities. One is it may be an exemplary jurisdiction where the both systems facilitate for a smooth settlement of juridical question. In this research, my main focus is this second part. Always we are talking about negative parts of our jurisdiction, because that we have got many laws in the country. Sometimes it may create complexities. Why can't we think in terms of positive aspects? Therefore, the main objectives of this research is to investigate whether and to what extent both the Roman Dutch law and English law are applied to the contract law issues of Sri Lanka. This the methodology followed is qualitative methodology, mainly that primary and secondary data have been referred. But this scope of this research will be limited, because that since this is a short study like this, I don't think that I am in a position to address each and every aspect of contract law governing the country. When it comes to the analysis, our substantive laws mainly governed by Roman Dutch law, except the statutory application, because that Roman Dutch law is considered as our common law. On the other hand, for the procedural aspects, mainly English law will be applicable, since that English had enacted some legislations towards this. And when we are demarcating which part of contract law will be governed by Roman Dutch law and which part will be governed by English law, the best thing is to demarcate the areas that the English law is applicable, because that introduction of English law had happened in two ways. One is statutory adoption, second one is judicial adoption. That English people believed on mostly statutory introduction. For example, for the format of some of the contracts, Prevention of Frauds Ordinance 1840 introduced some of the formats. For example, Section 2 and Section 18C. And Civil Law Ordinance mentioned for the maritime and the commercial matters should be governed by English law. Therefore, partnership, corporations, banking, agency, insurance, bills of exchange and sale of goods, all of these areas should be governed by English law. Except the Civil Law Ordinance, there are specific legislations, for example, bills of exchange ordinance, sale of goods ordinance, and Insurance Act, so on and so forth. All of these sphere will be governed by English law, basically commercial law matters. When it comes to the judicial adoption, there's some sort of dilemma in the application of judicial application when judges applying these concepts into a practical matter. For example, the matter of consideration and justa causa, this is a very famous notion among the scholars. and mainly for the commercial matters, that since the English law should be applicable, the concept of consideration should be applicable. The rest of the contract, that the justa causa should be applicable. That's the main conclusion that what I have gained by studying the panorama of case law in Sri Lanka. This part is really important in my opinion. That's a contract for the benefit of third parties. Since that contract, that English contract law derived from the concept of privity of contract, which is enshrined in the Doninger vs. Stevenson case, that third parties are not in a position to, third parties are not entitled for damages rather than who derives rights under the contract. But in Roman Dutch law, we have got a concept called stipulatio alteri, which has been accepted by this case, Sumanadasa vs. Silva. Under Roman Dutch law, stipulation in a contract in favor of third party may be enforced by such party when it was accepted by him. Therefore, that our judiciary is in a position to adopt this kind of concepts to our jurisdiction, rather based on English law concepts, though that English law has been changed by this legislation. That's Contract Rights of Third Parties Act 1999. We are not in a position to follow this English piece of legislation since after the independence, though we have got this Roman Dutch law concepts and we are in a position to apply those things. When it comes to the revocation of offer, that English law notion is an offer can be revoked until the moment when it was accepted. That's a famous notion. Even as scholars and as teachers, law teachers, we are teaching this notion. But Roman Dutch law based on other principle, in principle, an offer cannot be revoked after being made. That's a Roman Dutch law notion. But there are some exceptions. Offer is bound by the offer for the period of specified therein or the reasonable time period. That's the main notion of Roman Dutch law. When it comes to illegality also, basically that our courts followed English law mainly because that Roman Dutch law and English law equal in this scenario. But I found one of the problem here that with relating to the restraint of trade agreements, whereas the English law mentioned that this kind of contract are void unless proven as reasonable, Roman Dutch law does not recognize such a doctrine. Therefore, that still that there's a problem in that. When it comes to undue influence also, mainly that Sri Lankan judiciary followed English law because that Roman Dutch law borrowed from English law this in relating to this undue influence area. When it comes to remedies also, mostly the courts followed English law concepts, for example remedies and specific performance also. These remedies are derived from equity. And in conclusion, our judicial pronouncement on the issue have favored more towards English law rather than Roman Dutch law. Though our common law is Roman Dutch law, our judicial decisions more towards English law. I have identified some of the reasons. One is, as mentioned in the Codiswaran versus AG case, although the Roman Dutch law is starting point of the common law, that's not the ending point. Therefore, our judges are in a position to expand the horizons of law. That is one thing. The second thing is judicial attitude, because that English law is more practical and more writings available. When it comes to the Roman Dutch, that is really difficult for us to find writings except for Foots or Hugo Grosch's or any classic Roman Dutch law writers' works. And also mostly commercial matters are in superior courts of report. Other personal sphere contracts are not being reported, not being questioned. Therefore, that the case law, panorama of case law also reflected the commercial matters, basically English law, and also lack of scholarly writing after 1967, after the extensive work of Professor Veeramantri. There are no such extensive work on this. And in recommendation, that since the world movement is to reapproach of both civil and common law, for example, unification attempts they have already done. For example, Vienna Sales Convention 1980 and Unidriot principles for international commercial contracts, and in the EU region that we found this kind of very blended system they are followed. Therefore, that since we are blessed with these two main legal traditions, common law and civil law, and we are blessed with Roman Dutch law and English law, that our judges are in a position to go ahead with by utilizing all of these concepts by selecting the best out of the best. Therefore, that finally I would like to say, with this unification attempts, that Sri Lanka will be in an exemplary situation, even other countries to learn something. Therefore, finally we can be able to go ahead with this kind of these positive features rather than accepting the negative features. Thank you very much.